All right, well, it's now time to take a lot of the concepts from the last panel and put them to practice. We're going to be talking today about how we would go about, we have a hypothetical, and those of you that attended last year in London will find the hypothetical somewhat familiar, although we've changed it a little bit this year. And we're going to be working through the hypothetical and talking about how we would approach the scandal, we'll call it, from various perspectives. So before we do that, I'm going to have each of the panelists introduce themselves. I'll start with Sabrina here to my right.
My name is Sabrina Lombardi. I think I'm the other Canadian lawyer in the room. I am in Ontario, so I practice in common law Canada mostly, although I do have friends that practice in Quebec as well. I've been a lawyer for about 16 years now, and I have practiced almost exclusively now in class action litigation. Mostly plaintiff side, I can't say exclusively, but mostly plaintiff side litigation. I've had the privilege to actually do a common issues trial in a class action, and I guess that's a distinction as well.
Great, Charles?
I'm Charles Siegel. I'm a partner at Waters and Kraus, plaintiff's firm. I'm in the Dallas office. We also have an office in Los Angeles, and I do mostly mass torts, I guess you'd say, products liability work, mostly some commercial fraud cases, and I spend a lot of time these days on whistleblower claims as well.
JP.
Hi, my name's JP Carroll. I'm with Blackhawk Network. We're a global payments company, so we're based in the United States. We have offices around the world. We help with the last mile of class action settlements, and that's the payments to the consumers, to the class members.
Well, thanks. And as I was introduced, Paul Karlsgodt, I defend class actions in the United States. But without further ado, I'm going to read the fact pattern, and then we're going to discuss, again, how we would go about dealing with our various roles. So before I do that disclaimer, any similarity between any of the parties in the fact pattern and real parties, real people, is purely coincidental. All right, here we go. Headspace Corp. is a social media company headquartered in Seattle, Washington, USA, founded in 2015. Since its founding, Headspace has attracted more than 900 million users. ABC XYZ Limited is a multinational UK-based company that wholly owns Yeehaw NV, a global web services provider headquartered in The Hague, Netherlands, with approximately 1.5 billion active users. Both Headspace and Yeehaw offer targeted advertising and data analytics services to companies around the world. Combined, the two companies control roughly 60% of the worldwide digital advertising market. Users of Headspace and Yeehaw span individuals in over 100 countries, ranging from 18 to over 65 years of age. While a majority of the users are digitally savvy, almost all users are competent with technology and at the very least have access to email. The user terms of use for both Headspace and Yeehaw contain a provision that requires arbitration of any dispute in a class action waiver. So the disgruntled former CTO of Headspace is 29-year-old Curt Cobayn, that's spelled C-O-B-A-Y-N, recently gave a highly publicized expose interview in which he revealed that Headspace and Yeehaw had jointly developed a secret new technology known as Hard Biscuit, which it used to capture user web browsing activities across large portions of the internet in order to sell and exploit the resulting data. Numerous private bloggers and data security analysts began publishing articles substantiating Cobayn's claim. Sabrina Lombardi has been approached by several individual clients about filing a consumer class action against Headspace and Yeehaw in the Canadian courts for violations of privacy rights. Lombardi has been in touch with plaintiffs' lawyers in the United States, Australia, and the UK who are considering bringing similar actions. She has also been contacted by Claude Von Trapp, a Swiss graduate student and privacy rights advocate who has been organizing an initiative to bring mass privacy complaints to various European regulators. Cobayn recently retained Charles Siegel to represent him in connection with his termination from Headspace. Cobayn claims that he was fired for threatening to go public with revelations that top executives at Headspace and Yeehaw conspired to fix prices on data analytics services both companies were offering under various government contracts, including contracts with the United States, Canada, and the Netherlands. Among Cobayn's claims is that Headspace and Yeehaw bribed a high-level Dutch official to keep quiet about the scheme. Siegel recently met Lombardi at a Global Class Actions conference, and they discovered that they both had clients with claims against Headspace and Yeehaw. I, Paul Karlsgodt, have been engaged by Headspace to defend several privacy class actions brought in the state of Washington, alleging violations of various common law and statutory claims due to the use of the hard biscuit tracking cookies. I have also been approached by a different U.S. defense firm that represents Yeehaw in similar litigation that is brought in federal court about forming a joint defense group for the U.S.-based privacy litigation. So that's our fact pattern for now. JP is not going to get left out. He'll come into the scenario later. But I'm going to start with Charles. Charles, his client, Mr. Cobayn, is a whistleblower, and ask Charles, just generally, based on that fact pattern, how do you start? What's going to be your approach to your representation of Mr. Cobayn?
Well, I want to start, this hadn't occurred to me, even though I've read the pattern several times before today. It never occurred to me until just now, when you read it, that this has got to be the first hypothetical ever to involve Curt Cobayn and the sound of music. It's really, hats off for coming up with that one. So Cobayn in this example has a claim, has a few claims that a lawyer representing whistleblowers would think about bringing here. And I think it's relevant here because these frequently exist alongside class action claims. But they're very important. It's very important to keep them separate in ways that I'll talk about. But I think it's relevant for this conference, and I actually think you could profitably have an entire conference about whistleblower claims and how foreign whistleblower claims can be brought in the U.S. and so on, which I'm going to talk about a little bit. So obviously, the first claim that comes to mind here on Cobayn's behalf is retaliatory discharge, wrongful termination, that kind of thing. And that is not what we specialize in as whistleblower lawyers. I'll get to that in just one second. But those claims are very important claims, and obviously what can be recovered in those claims are economic losses for the loss of your livelihood, and also in some instances non-economic damages like psychological damages, worry, emotional distress, that kind of thing. Those claims exist under our federal law in the United States, and they exist under almost all state laws as well. And so those are first and foremost the claims you would evaluate if somebody like Cobayn in this situation came into your office. What other claims might he have? Well, the hypothetical stated that he is aware that a bribe was paid to Dutch government officials to ignore the problem and to suppress any knowledge of the problem. Now, that's a pretty important fact with a lot of implications. Just very briefly, to just dwell very briefly on the U.S. whistleblower recovery scheme, leaving aside the more employment-related claims, in other words, for wrongful termination, retaliatory discharge, and that kind of thing. What kind of claims can a whistleblower bring in the United States? Well, the main one is called a qui tam claim. Qui tam is the start of a very long Latin phrase that I can never remember exactly how to pronounce. It's qui tam pro domino something. He who sues in the name of the king as well as for himself. And so a whistleblower is bringing a claim saying, I am aware of this wrongdoing, and I am suing in the name of the government. And basically under what's called our False Claims Act, which is a very old statute, it's about 150 years old now, a person can bring a claim saying, I am aware of fraud and the government is being defrauded and I am suing in the name of the government. The law originated in the United States. It's also known as Lincoln's Law because it got its start in the era of the Civil War when the Union Army was regularly being defrauded by contractors. The Union Army, for example, wanted to buy 100 mules from a farmer, and the farmer would sell the Union Army 100 mules, and 80 of them would turn out to be lame, or they wouldn't even be mules or something. And that is where the law originated. It was given much greater potency by new legislation passed in the 1980s. I should say that just kind of an interesting fact about our political system, the most stalwart legislative champion of the False Claims Act in the United States over the last several decades has been Republican Senator Charles Grassley. He's, from my standpoint, got absolutely lamentable positions about everything else on earth, but he is a absolute stalwart defender of the False Claims Act and of the rights of whistleblowers, and has routinely fought off attempts by largely other Republican legislators to weaken the False Claims Act. Sadly, he's in his 90s now, although he was just last week reelected to his 6th term in Congress. He's actually now been an elected legislator at the state or federal level for about a quarter of our nation's history. And long may he's the one Republican I regularly donate to. So long may he continue. As I said, the statute was given much greater potency by some amendments in the 1980s, and basically it incentivizes whistleblowers to come forward and bring claims that are filed under seal. That's one of the great incentives, because a lot of times these are filed by people still at their jobs and who can't afford to leave their jobs yet. They're filed under seal. The defendant is not initially served with the complaint. Only the government is served with the complaint. And the government then is given a chance to examine the claim, which usually takes anywhere from 6 months to a couple of years, to interview the whistleblower, to find out, look at the documents the whistleblower may have, to interview other witnesses the whistleblower suggests talking to, and then the government makes a decision as to whether or not to intervene in the case or not. If the government intervenes, great. The case is unsealed. It becomes a matter of public record, and the United States or a state government, because most states have these False Claims Acts as well, the government intervenes and takes over the prosecution of the case. If the government doesn't intervene, that is not the end of the case, formally speaking, although in practical terms it is often the end of the case. But the relator, that's what the plaintiff in this context is called, the relator. The relator has the right to go forward with the claim on his or her own. It's a daunting prospect, but it can be done and frequently is done. And to make a long story short, if the government recovers fraud or recovers damages for having been defrauded, then the whistleblower, either in an intervened setting or in a non-intervened setting, then the whistleblower gets a percentage of what the government recovers. Usually, depending on a lot of different facts, anywhere from 15 to 25%. Under some state acts, it can even be more. Since the government is regularly being defrauded every single day of the week, there's frequently a lot of dollars at stake. And so the recoveries can be large, and the whistleblower's share of the recoveries can be large. We, the lawyers, represent relators on a contingent fee basis, and so our contract entitles us, if we win, to a percentage of what the whistleblower gets. So the lawyers get a share of what the whistleblower gets, which is in turn a share of what the government recovers, either by judgment or settlement. There's also a fee-shifting provision so that the defendant is also liable for the lawyer's hourly fees and for the litigation expenses. So that's basically our whistleblower regime in a nutshell. There is a variant, and that is, by the way, that is a lawsuit. That's a lawsuit under the Federal Act, usually filed in federal court under the False Claims Act. And there are a million different varieties of fraud that are, practiced on the government every day. Most of the suits tend to be in the healthcare field, or the largest single block of them, I should say. But there are all kinds of, there's weapons procurement and all kinds of products being sold to the government, services being delivered to the government, and so on, that can be the subject of fraud. In this context, what you would have, and that is a lawsuit, as I said. The SEC also has a whistleblower provision under which a person can file a claim for securities-related fraud. That is not a lawsuit. That is simply a claim filed directly with the SEC, again under seal, again confidential, so that the employer or other people in the whistleblower's field don't immediately find out about it. And those claims can take a long time. They're not lawsuits. They take a much longer time to be investigated. But again, if there is a recovery, the whistleblower gets a share of what is recovered by the SEC. As relevant to this example, the Foreign Corrupt Practices Act applies via the SEC. And what the Foreign Corrupt Practices Act forbids is the bribing of foreign government officials to achieve some improper aim. And here what you have is the Dutch government being bribed by Headspace, I think it was, to keep this quiet. Well, that's an impermissible aim. Clearly, the briber is subject to this FCPA/SEC provision because the briber is a U.S. company. The other company, who might have, tacitly been in on the bribe or paid part of the cost of the bribe, is a Dutch company. If that Dutch company's securities are traded in some form or fashion in the United States, then it would be subject to these provisions as well. But that is the claim that might immediately jump out to a whistleblower lawyer, is again, I first said the wrongful termination claim, but the claims that would be filed under seal with the SEC, not a lawsuit, but with the SEC invoking the provisions of the FCPA.
So various claims that are not class actions,
right,
but have a collective aspect to them.
Yes, yeah.
All right, so now let's talk about Sabrina's case. So now Sabrina's been asked to represent clients in a completely different aspect of the scandal. There are privacy implications, and you've been consulted by some folks that want you to represent them in a class action in Canada. Talk about how you're going to go about handling that case.
Well, the first thing I'm going to do is breathe deeply, because our privacy laws are not, they're in flux right now, and they're changing. So we have privacy legislation across our various provinces that differs somewhat. It doesn't always apply to the private sector. We have 2 new acts that were just proposed this year, in fact, that sort of fit this scenario very well in terms of trying to regulate this space in terms of collection, retention, and use of information, but those haven't passed yet. And so I have to think about the case law in this area, and that is also varying not just across the country, province to province, but court to court as well. On the one hand, we see some of our Canadian courts a little bit reticent about allowing these actions to come forward where there's no real damages or harm that is, evident or that can be shown, to exist right off the bat. They don't like that side of it. On the other hand, you have courts who are very interested in the privacy torts that are being used to try to, I guess, create damages in this sphere. So I would have to think, long and hard, not just about whether or not I can bring the case forward. And I would certainly be consulting with experts to see if there was a way to quantify damages right off the bat, because that would be one of the most important things to figure out as early as possible. But then I'd also have the consideration of which jurisdictions. So even within Canada, well, we don't call it forum shopping or anything like that. We're not quite like the US in that way. Our jurisdictions are changing though. It used to be much more uniform. It used to be common law Canada and then Quebec, which is our civil law jurisdiction. But now even amongst our provinces and our jurisdictions that are common law, things are changing, especially when it comes to certification of class actions. Ontario, where I mainly practice, though I practice pretty much everywhere else as well, was one of the first regions to bring in class actions not too long ago in the grand scheme of the law. Back in the early 90s is when that legislation came through, where we could start bringing class actions forward. And Ontario was the jurisdiction where you could bring a national action. And so if you could get certified, you could basically wrap up the whole country into your opt-out class action. Pretty easily. We have a 5-part test, not a 4-part test like in Quebec, and it wasn't that hard because when we were fashioning the rules and setting the test, we looked to our US friends and we looked at their class proceedings legislation, and we avoided some of the hurdles that we perceived to be there. 2 of them being the predominance that we heard a little bit earlier about, and superiority, these 2 concepts where the common questions had to predominate over the individual issues that remained in the case, and also it had to be the superior way of dealing with the matter as opposed to dealing with it in some other way. So for a long time, we were able to avoid those specific gates and hurdles. And so we were certified fairly easily if we met all the other criteria. But now Ontario very recently amended its legislation and has introduced both predominance and superiority. And so thinking about where exactly to bring a case like this, given the flux in the law and the changing attitudes of courts across the country, would be the place I'd spend most of my time at the beginning in considering this action.
All right, so what about exchanging information? You know that there are others in the US and elsewhere that are bringing similar lawsuits. How do you go about sharing, or is there any prohibition to sharing information with the lawyers in those cases as well as with Charles?
So certainly from my end, there's no problem in sharing information. I'll share everything I can. I'm not privy to a lot of information until after I'm certified. So I don't have discoveries prior to certification. So really, I'm looking to Charles to try to get as much information as he can share with me that I might not otherwise have access to because of the fact that I don't get my discovery until after the fact.
And Charles, from your perspective?
Yeah, that is completely true from the standpoint of working together on mass actions or class actions, and we would, we regularly share information with plaintiffs' counsel, obviously in the U.S. and in Canada and everywhere, in any kind of case that similar litigation that we're working on. It is important to know when I said that the whistleblower claims, both the lawsuits under the False Claims Act and the claim forms that you file with the SEC are filed under seal, that is an extremely important rule. And the violation, any kind of violation of the seal is basically punishable by death. I mean, it's punishable by dismissal of your case. And there are bad instances of that having happened. I mean, the whistleblower cannot, post on Headspace that I've just now filed a whistleblower claim. And you're really not even supposed to tell your friends about it, and you're not supposed to say anything about it to anybody, nor is the whistleblower's lawyer. Now, would that prevent Cobayn from talking to you about bad facts that he knows about these companies, I think it would be okay to simply talk about the facts, but that would have to be navigated very carefully. That's just
Right.
something that would have to be approached very carefully. Yeah.
All right, but right before we get to the end of the hypothetical, so that we can get to JP's part of this, I'll just address very briefly from the defendant's perspective. I've got a little piece of this scandal. I represent, I guess it was Headspace in the privacy class action that was brought in Washington State. Presumably there are privacy class actions brought elsewhere, and there are there's an antitrust case, I'm sure. The Ketam action and the actions that Charles is going to bring. In my experience in dealing with especially large multinational companies, the coordination on the defense side can be difficult, if only because with a large legal department, a lot of times one hand doesn't know what the other one's doing. And so one of the things from a defense perspective that I've learned is you sometimes have to really push your client to get that level of coordination, because oftentimes the in-house lawyer that you're dealing with on the defense side doesn't necessarily know what other aspects of the legal department are doing, even though this is really sort of an interconnected scandal. And so I think from my standpoint, the one thing that I would look to here would be to be fairly aggressive with my client contact and say, look, these are interconnected issues, and we need to be in contact with the various lawyers that are defending you in other jurisdictions. And usually when you do that, you open some eyes and that level of communication starts, but it doesn't happen just naturally. And so that's one of the things that I've experienced.
I would say one thing I think that's interesting about the defense of these cases. As I said, when a False Claims Act case is filed, the government has a certain period of time in which to decide whether to intervene in the case. And the basic investigation involves interviewing the whistleblower, looking at whatever documents the whistleblower has, talking to witnesses that the whistleblower may recommend either by name or by job. And, the whistleblower might say, well, I don't have access to, I only have access to these emails, but you might ask the company for access to the emails of the following different people, and the government is entitled to send a subpoena to Headspace without disclosing that a Ketam case is filed. Headspace lawyers may just open the mail one day and and see there's a subpoena, and capable, experienced ones will usually pretty quickly think, maybe there's been a Ketam case filed.
Right.
Or something like it. Yeah, I wonder who that could have been that filed that case. Yeah.
All right, so we're going to move to the end of the hypothetical. So this is what's happened. Headspace has been the subject of a hostile takeover by a gentleman named Elon Musk. Again, no, any coincidental relationship to any real person or any relationship is coincidental. But he's decided, look, we've got to settle all this stuff. So Headspace has sort of tasked all of its defense lawyers to negotiate really a massive settlement of all claims in the world. And there are many, as we talked about in the hypothetical. And so we've reached out to Blackhawk, and we're trying to figure out what's a good approach to the distribution of the funds from all these settlements that are being brought in both the United States. There's one here in the Netherlands. And there's one in the UK as well. So talk a little bit about how you would approach that.
Sure, and this is, possibly a daunting task, right? Paying out hundreds of millions of people across hundreds of countries. How do you handle the different currencies? So, we do have, a proposed solution, and that's really, this is really the most important part. We think is actually getting the benefit to the consumer, getting the money to the class member. That's a main part of the class action instrument is doing just that. So, I would, in this case, have 4 recommendations. It's based off of best practices that we've employed in the United States and translate to a global distribution. So the first one is providing dynamic choices. So choice is huge when you're delivering payments. You want to give the consumer, the class member, multiple options for how they get their benefit. In this case, when you have different jurisdictions, different currencies, different geographies, you want to provide a dynamic choice. So the options for an American it's going to be different than the options presented to somebody in the UK, Amsterdam, and so on. So we did this exercise last year, and just to give you an example, you'd want to look at what the popular payment options are for each jurisdiction. In the United States, that's ACH, that's PayPal, it's Zelle, as well as a non-banked payment option like a prepaid card. So those are the options you'd want to present in the United States to those class members. In the UK, we looked at this last year at this event. It would be bank transfer, PayPal, and then another popular option in that jurisdiction is Visa or MasterCard. So you'd want to give them that prepaid option as well. In advance of coming here today, I looked at what is popular in the Netherlands, and it's a bank-to-bank solution called Ideal. I'm sure the locals know what this is, and another one called Maestro, which is a prepaid MasterCard that you'd want to be able to let people top up. So the options presented to those in the Netherlands should include those two, as well as potentially others. So those dynamic choices based on jurisdiction, that's going to be very important. So the second theme or second strategy would be to take note of the demographic that you're serving. You want to do this in general, right? In this case, it's a digitally savvy, potentially younger demographic, somebody who's on Headspace. They've provided their email. They have an email address. So you want to cater to this kind of youthful demographic. Now, in addition to this being a digital based solution for the digitally savvy younger person, you also want to take into account that they might not have a bank account. The young, for whatever reason, are not signing up for bank accounts like older generations have done in the past. So you want to make sure that there's an unbanked option in those options that you provide. Third strategy point would be to take into account the type of class action. So this is a class action that has concerns around data privacy. You want to keep that in mind when you're thinking of options, and you want to provide an option that does not require sharing of personal data, like a bank account, like a username and password to access your bank, for example. So you want to potentially provide those options to give the people the choice, but you want to have other options that don't require that sensitive data as well. And then the last piece of the strategy would be to take into account the global nature of this, right? So you're sending hundreds of millions of payments around the world. You don't want to do this with a physical check. And checks are big in the United States. I know that they're in other countries as well. You want to avoid a paper check distribution because obviously that's going to be cost prohibitive. You want to go digital, and obviously that's where everybody's going, across industries, and obviously we've been able to build out a digital solution for the class action space. And then of course, you're reaching out to Blackhawk for our advice and our guidance. You'd want, we sit behind the administrator, so you'd want to find and hire, the best administrator, and you've probably met a lot of them, over the last couple days. Another one that really pioneered this digital choice feature is AB Data, and they would be one potential option. So we would sit behind the likes of them to facilitate these payments, and yeah, that would be the core strategy.
All right, so we have now solved the biggest scandal of today. Why don't we open it up to those of you, we've covered the US, we've covered Canada, we've covered kind of how the payment system would work, but I'd be interested if there are thoughts or questions from members of the audience on how this might play out in your jurisdiction. Does anybody have anything they want to offer? I think everybody's ready for lunch. Final thoughts from the panels? Why don't I start with Sabrina?
It's an interesting space, privacy regulation. I think it is developing across the world. And I do think, or at least I hope, that our regulators or our legal systems find some common ground, some common thread, because otherwise we're going to end up in a situation like we have in a lot of the consumer cases, where you end up with different results for different people based on geographically where they are, when that really shouldn't matter in the privacy space.
Charles?
What I would say is, there's been some back and forth about whether it's desirable to import U.S.-style litigation into, European countries or foreign countries generally, or U.S.-style class action litigation. And I would just say I think it would be highly desirable to import the whistleblower laws that we have. There are whistleblower protections of one kind or another in lots of countries, obviously, but incentivizing them to come forward with a monetary reward and with, that guards against, that is some insulation against the possible downsides of being a whistleblower, which are many, losing your job, being blackballed in your field, and so on, I think would be a really salutary thing for any country.
JP, final thought?
Yeah, and it's, we're the payment company behind, a few layers down, so it's just fascinating to learn about the class action instrument, how it's expanding internationally, and how we can, help, from the backside and, get people paid. It's been a pleasure, yeah.
And I'll just end by saying that I want everybody to understand that when Headspace did all these settlements, there was no admission of liability. Thank you all for your time.